Domestic violence comes in many forms. It doesn't have to be physical violence. Emotional abuse and coercive control is part of domestic violence. And on January 1st, 2021, the legislature added coercive control into Family Code section, defining as pattern of abuse that results a victim feel isolated from friends and family. So if the abuser or alleged abuser creates surveillance on the victim, restricts the movement, overall disturbs the victim's calm and peace. And it sounds really vague, and I will give you a couple examples. This legislature change was inspired by the marriage called Nat Carney in 2009. And in that case, wife separated from her husband, he hacked into her private emails, and he then knew everything she was doing, traveling, feeling, and he was reading emails and he used it against her. When she filed for domestic violence restraining order, the judge, Superior Court judge, said, no, there is no domestic violence because the code section 6320 back then was defining abuse as stalking, harassing, or threatening, which was not in this case. And the judge said, well, he didn't hit her, he just read the emails, so I don't find there is an abuse in this case. And that was it. She appealed, and the Court of Appeals said, actually, if someone is hacking into private communication, that's falling under disturbance of peace in the way that the abuser's conduct is resulting in destroying the other person's or the victim's calm. And so after that case, the code section was updated. I created this book to help you understand the divorce process without getting lost or without getting a heart attack. You can buy it on Amazon in all formats, including audio format. Since then, there was another case that came out in 2021 called FM versus MM, where they first met and he was love bombing her. And then at first he said, why don't I pick you up from your work because it's dangerous at night to walk home. And then when she wanted to go for parties and events at her work, he's like, don't go. There are such weird people working there. Why don't you work from home? I will help your business. And then let's open a joint account. So basically, he slowly inserted himself into her life to the point where he was controlling her finances. He was controlling her movements. He was questioning her way of spending in a way that she was afraid to tell him no. He was ridiculing her in front of other people. And this was not just an isolated event, which is the antidote from coercive control, where in other cases of appeal said, well, it has to be a pattern. It cannot be just an isolated version of exchanges in text messages or a fight between a couple. It just has to be a truly developed pattern over time. And in this FMM case, it happened over time slowly, where at the end she was questioning herself, feeling isolated. It reminds me actually of the movie in the 50s called Gaslighting, where she was not able to believe her own version of events, where she questioned every purchase she made. She eventually felt that she cannot survive without him because he gaslighted her to believe that nobody would want to be with her, and so on. Coercive control is a real situation of a victim feeling powerless, unable to say no, and eventually feeling completely isolated, so there is no soundboard of family and friends, and that results in an emotional disturbance of calm and peace, which is part of the abuse. The consequence, if there are children involved, the court could say that if there is a pattern of abuse as a version of coercive control, then there will be a 30-44 presumption. 3044 presumption says that the court in a custody proceeding, it doesn't have to be domestic violence proceeding. So the victim does not need to file for domestic violence. Really important. Again, a victim does not need to file a request for order for domestic violence or file any type of request. It can be pled in any responsive paperwork. The abuse, once the court determines in any custody proceeding, domestic violence or custody proceeding, then 3044 presumption will say that if abuse perpetrated on the victim was perpetrated on the victim, then the victim can get sole legal and physical custody, and the other parent will have to go through different programs to rebut the presumption by coming back and say, well, I've done all these programs that you court assigned me to do. Usually courts assign to do parenting classes. In San Francisco, the courts prefer Kids Turn website to look and attend those type of classes. And upon completion and showing that there is some time that passed, and then the alleged abuser comes back, or if the court already found that there was an abuse, then abuser comes back and says, well, I now want to rebut the presumption and would like to have joint legal custody. But in the meantime, with that 3044 presumption, the custodial parent will have sole legal custody, meaning make decisions about movements and everything else. So a lesson from this video, I would say to watch for a pattern that slowly will creep in where you will not feel that you can be unrestricted in your movements, where there are track devices in your car that at first are placed as for security reasons, and then the question will be, well, why did you go there? Why didn't you not go there? Why did you tell me that you went there? And things like that, where you would feel restricted, controlled. So watch out for that. If you notice it happens to you, of course, call National Hotline for Domestic Violence. I hope this video was helpful, and I will see you soon in my next consultation or in my next YouTube video. Bye!